Hello, everybody. Welcome to the Debt Hotline. We are super excited for tonight's guest and our topic. We're going to be talking about bankruptcy tonight. And just for starters, I wanted to say that my name is Hannah Locklear. I am with Team Solo. At Solo, we help people respond to debt lawsuits and represent themselves. We also help people settle debt. If you've been sued for debt, you can use Solo to respond to the lawsuit and represent yourself, as I mentioned before. And like I said, we're really excited to talk a little bit about bankruptcy tonight. And I wanted to take a moment to introduce our guest. So we have a really experienced guest tonight who is an attorney actually with Guardian Litigation Group. And joining us tonight is Stephen Nowak. So Stephen is a senior associate attorney at Guardian Litigation Group, where he defends the rights of consumers that are facing financial hardship. Like I said before, he's very experienced. He has decades of legal experience, and he specializes specifically in bankruptcy, civil litigation, and real estate matters. Stephen earned his Bachelor's of Arts in Business Marketing from the University of Delaware and graduated cum laude from Widener University School of Law before being admitted to the Delaware Bar in 1987. So he draws on years of courtroom and consumer advocacy experience and helps clients understand their options and regain control over their financial futures. Stephen, thank you so much for joining us tonight. Can you fill in any gaps that I might have missed in your bio?
No, Hannah, and thank you for that terrific introduction. I think you covered it, and I'm super happy to be here and field some questions and hopefully help some folks get the guidance they need to if it's bankruptcy, get a fresh start and get on with their lives.
I love it. And so I mentioned this in the bio, but you have decades of experience in bankruptcy law. Is that right?
Yes. I go way back in bankruptcy law, but I'm also current. There's been a lot of changes in bankruptcy since I started. There's the electronic filing and the use of Zoom in the meetings. And so there have been a lot of changes, but the basic structure of bankruptcy pretty much stays the same. And that's good because it helps predictability. It helps people know, like, okay, what are my rights? And they're not wondering, what are my rights today versus tomorrow. It's a pretty stable area of the law.
Yeah, I love that. And it's nice to know that there is some stability for people facing financial hardships who are considering bankruptcy. I know that a lot of people listening today are probably considering bankruptcy and maybe dealing with debts that have become hard to manage. So we're excited to jump into this topic. I forgot to mention earlier, but our topic for tonight is specifically, can bankruptcy stop wage garnishment, foreclosure, or lawsuits? So with that in mind, I did want to ask a few questions to you, Stephen, regarding bankruptcy. Sure. And just kind of pick your brain as an expert in this, this realm of the law. So my first question for you is, what kinds of debt collection actions does bankruptcy immediately stop?
Well, to understand that, one thing that's important concept that goes with that is something called the automatic stay. And what the automatic stay is when you file your bankruptcy petition, it's like the court extends this protective bubble over you that keeps anybody from trying to collect any money from you while the court is trying to sort out who should get paid, from whatever money you might have. So the automatic stay will stop state court actions if you've been sued in a state court trying to collect money. It will prevent any judgments from being entered. If there's a foreclosure, the foreclosure will be stayed. If there's a garnishment, the garnishment will be lifted. Pretty much one of the only things that I think is relevant for our crew right now is child support is not stayed, because child support is carved out as an exception as far as getting a discharge. You can get a discharge for all your medical bills, your credit card bills. But there's a couple things. Student loans, it's theoretically possible, but I haven't seen too much success with people having student loans discharged. But child support is another one that the court's not going to let you walk away from your child support obligations. And so while the case is started and pending, even though you have that automatic stay that's stopping everything else, you're always going to be obligated to pay your child support And so those child support garnishments will continue. If you've got arrears in your child support, there's a way of handling that once you get into the bankruptcy. But probably the most notable exception is the child support. But pretty much everything else, you can have stayed pending the outcome of the case.
Gotcha. So it sounds to me, just to kind of reiterate what you were saying, that most debts can be kind of eliminated through bankruptcy through that automatic stay. And correct me if I'm using any of the wrong lingo here, but the one exception would be in most cases child support, but there may be other exceptions as well,
Right,
like
child support enforcement. The automatic stay just stops the music. It keeps anything from proceeding, and it allows the bankruptcy court to sort of marshal the assets of the debtor and say, well, what do you have that could be liquidated to pay off your unsecured creditors. So I had a client who had a very expensive car. It was a show car, and it was paid for in cash. And she lived in a state where there was no, there wasn't very good protections for the liquidation of assets. And I had to tell that person, you're going to lose that car if you file for bankruptcy. There's no way the court's going to let you keep, an $80,000 car that you own outright and, have your unsecured creditors, go packing. Really but the main areas where I see people looking for relief is medical bills, credit cards, signature loans, and even in some cases where if they've had a vehicle and there's been a repossession, sometimes the creditor comes back and says, you still owe us $10,000 for the car that you didn't pay for and we repossessed it, and you still owe us $10,000. Even though that comes out of a secured loan, a car loan, the deficiency, that is the amount that the creditor was short in paying off your loan, that can be discharged. So even if you've had, in a lot of cases, that's what really pushes people over, is they have deficiency on a repossession, and it's when I'm going to, I already lost the car. Now I have another $10,000 to pay. Bankruptcy would allow you to get out from under a debt like that.
So what about, like you mentioned, you had a client that had a really fancy car that she had already paid it off in cash. And, let's say collectors were coming after her, maybe they had already won a case and they were trying to like repossess the car, or not repossess, but like put a lien on the property. Like how would bankruptcy work in that sense? Would it stop collectors from trying to seize that asset?
Well, a scenario that could come up is where our hypothetical vehicle owner owes money on a credit card, owes $15,000 on a credit card. That's a pretty big one. Let's say she goes to court, and the court hears the plaintiff's evidence and enters a judgment against our car owner for the $15,000. Under state law, the creditor has the right to do post-judgment execution, meaning they can, once a judgment's entered, they can ask you all kinds of questions about your assets. And if they know you have this vehicle and they know where it is, they can ask the sheriff to levy on the vehicle, meaning take possession of the vehicle, like a repossession, but it's like a repossession in that they're taking the car to sell it to satisfy a debt. But this is an execution on a judgment rather than a repossession by a secured creditor. Bankruptcy would see in that person's case, she would have to do a Chapter 13, and this might lead us into another question. She might have to do a Chapter 13 because she might say, I want to keep my vehicle. What do I need to do to be able to keep the vehicle and then give the unsecured creditors what they would have gotten if you would have taken the vehicle. And And that gets into the difference between Chapter 13 and Chapter 7, which most of the folks that I meet in my debt settlement work have already exhausted all their means, and when at some point bankruptcy becomes the best option for them at that point. But if you have assets, they're not going to let you keep them and walk away and leave your creditors, with an empty sack.
Yeah, so that's actually a perfect segue into another question that I had on my list of questions for you, which is, can you explain to us a little bit more about the difference between Chapter 7 and 13, specifically in terms of like foreclosure or asset protection?
Really super great question. So for consumers in general, there's two flavors of bankruptcy, or two types of bankruptcy. One is Chapter 7. The chapter part just refers to the chapter of the bankruptcy code that sets out the rules of how Chapter 7 works. Chapter 13 is another chapter. It's the 13th chapter, and it sets out all the rules for Chapter 13. Chapter 7 is what they call the liquidation chapter, where essentially what they're doing is you fill out forms that are submitted to the bankruptcy court. They're prescribed forms by the court. You fill them out. And what happens at that point when you file your Chapter 7 petition with all your documents and your schedules, they're going to appoint a trustee to look at your paperwork. And the trustee's job is to play referee between the creditors and the consumer. And so, as many consumers know, all the credit card companies are all coming in all at the same time. And that's pretty much why the debt becomes unmanageable, because everybody wants everything all at once. And so when you file for Chapter 7, it does give you that protection of the automatic stay. And then it's the trustee's job to say, okay, is there any money here in this person's, possessions and income that would allow them to pay something on their unsecured debt? And if you prepared the case right, you'll know whether or not you're going to be Chapter 7 or Chapter 13. Sometimes you'll file as a Chapter 7, and the trustee will say, well, you make enough money that you can pay your expenses, and there's still some left over for your unsecured creditors. So then the trustee might say, you need to go to a Chapter 13 plan, because you do have resources that can go to these debts. Whereas in a Chapter 7, it's I rent my house, I have an old car, I don't have any jewelry to speak of. My home furnishings are, what home furnishings are worth. And that person really doesn't have any money or any income that's going to enable them to pay anything back. The trustee looks at that, he verifies, he calls the case a, quote, no asset case. And then once he designates it as a no asset case, it gets on track for discharge. There's a 60-day waiting period for unsecured creditors to file objections to your discharge. So suppose you come into bankruptcy, one of your debts is a Royal Caribbean credit card that you bought, an expensive cruise for the family 3 months before you filed bankruptcy. And that's going to be the kind of thing that's going to raise a red flag and say, the trustee's going to say, wait a minute, you must have known 3 months before this happened that you were going to be filing for bankruptcy. You took out this card, you ran it up on something that doesn't produce an asset. Like, you didn't go buy jewelry, you bought a vacation, which, doesn't, you can't grab that value back. It's, pleasant memories. But, and so there's this period where there's objections to discharge. It very rarely happens. I mean, the Royal Caribbean case is the one case that I had that did that. And then once the trustee has verified that it's a no asset case, has set the deadline for filing claims, no one respond, or set the deadline for filing objections, there's no objections, and the court issues a discharge. It's about a 4-month process for Chapter 13. For Chapter 7. Chapter 13, You see Chapter 13s used a lot in mortgage foreclosure because let's say I haven't made my mortgage payment in a year, which, is easy to do when you don't have resources. And so it's a $2,000 a month mortgage. I owe 24 grand in mortgage arrears. The mortgage company saying, you've defaulted. We want all the money now. And if you don't give it to us, we're going to foreclose on the home. And, you don't really have any ability to get other credit to buy out this foreclosed mortgage. And so what happens in that case is what I recommend is person would file for a Chapter 13, right? Which is just like the Chapter 7. But the difference is you're saying this one debt, this $24,000 that I owe on my home mortgage, I don't want to lose my home. And so I'll keep up my mortgage payment like I'm supposed to, starting with when I file. And then that 24,000 goes in. It goes into the Chapter 13 plan. And by taking deductions from the debtor over the course of a 36 to 60 month plan, that $24,000 can be repaid over time. So basically you go in, and this can happen if there's a sheriff sale. I've seen this happen where the auctioneer is, he's rattling off his spiel about, what am I bid? And so attorney walks up and hands him the bankruptcy petition. And it's like, okay, it's off the list, moving on. So that's very powerful. If somebody's facing mortgage foreclosure and they can make the payments, Chapter 13 is definitely the way to go. So that you can take the opportunity to catch up, because people get, you get unemployed, you have a sickness. People don't, there's lots of reasons why people get behind on their mortgage, and they shouldn't lose their homes. And the Chapter 13 allows them to catch up without making them lose their home.
Yeah. That's so cool that, our government gives us options to, protect like our homes if we get into a situation where paying our mortgage feels like undoable, unmanageable. Because I think what you said is so true to your point about there's all sorts of reasons why people may fall behind on their mortgage. I don't think anyone enters a mortgage agreement thinking, oh, I'm just going to eventually stop paying, right? Like
Right.
life happens. You might get sick or have health issues or unemployment problems, COVID, there's so many reasons why debt can catch up.
100%.
And
And
there's gonna be a stigma against it, like, I think there is oftentimes a stigma against bankruptcy, and I think it's really, quite amazing that the US government gives us this option, and our legal system gives us this option to protect our assets if life does happen and unexpected things happen and we fall behind on our debts.
well, it's interesting that you mention that, because bankruptcy is actually provided for in the Constitution. It's one of the few areas that the Constitution says, no, we're not going to give that to the states. We're going to hold that as the federal government, so that there's uniformity in the application of bankruptcy law. And so you're going all the way back to the Constitution. This is, the idea that people need a fresh start is something that's been, in the culture for literally hundreds of years. And one thing that's good about bankruptcy is that it encourages people to take chances, to open that store, to try to, produce that product. And if it doesn't work out, you can, it's going to hurt your credit, but it allows you to start over again. And there's lots of successful businesses that started out with bankruptcies, before they figured out like exactly what they were doing. So the other thing I really try to make sure people are aware is that, there's a lot of societal shame around bankruptcy. And I think it's probably the work of the banks, because if you don't pay them, they want you to be ashamed, but they have no shame about charging 25% interest and $45 late charge and $45 over limit fee. And it's just untenable. And so, And so I try to tell people, like, be kind to yourself. A lot of what you're facing is not your fault. A marriage breaks up, you're unemployed. I mean, that's not your fault. And so dealing with the client's shame when they come in, I really try to make sure that they are kind to themselves about um, about how they got into this situation, and that they're going to be able to get a fresh start and be proud again of how they do in the post-bankruptcy world.
I love that, and I'm sure it's like a relief for your clients to hear from an attorney, like, you don't need to feel so ashamed of this. Like, there is hope, and you will get a fresh start. That's amazing.
Yeah, and it does, people are entitled to this. They've been, this is not something new. This has been provided for in the law for, since before we were a nation. And so, to feel like it's a bad thing to avail yourself of, I just think people have enough shame around collectors and, not being able to pay this person. I think the emotional piece of it has to be something that the attorney is going to recognize, to help people. I mean, you can help them with their debts, but you can also help them, be okay with it emotionally.
Yeah, I totally agree with that. Well, let me ask you another question. We'll kind of pivot away from like the difference between chapter 7 and chapter 13. And I wanted to ask you, you know, one common question that we receive at Solo is, does bankruptcy permanently stop a wage garnishment, or is it just a temporary thing?
That's a great question. So let's take a scenario where a person they were sued in state court. There was a judgment entered against them. There's a wage garnishment pending, and now they really can't afford anything because now that wage garnishment's going out. If they file for bankruptcy, that will stop the wage garnishment, except child support. But that will stop the wage garnishment. And if the debt is not discharged, the wage garnishment will start up again when you get out and you get your discharge. If for some reason, let's say it was that Royal Caribbean credit card, and you went to state court, you lost, you had a judgment entered against you, and now they're garnishing your wages. If you go into bankruptcy and for some reason the court says, no, you're not getting a discharge as to the Royal Caribbean card because that was, fraud, abusive. If the garnishment is on that particular card, it's going to survive the bankruptcy and it's going to start up again. But in 99% of the cases, 99.999% of the cases, you get a discharge. So if you're being garnished on a credit card that wasn't, was just, gas, diapers, and food, there's no basis for objecting to it. The garnishment will go away once you get out of bankruptcy because the underlying debt goes away. The discharge makes that underlying debt go away. And so the garnishment can't, and it brings up an interesting point. Once a person receives a discharge, there is a very strict federal law prohibition on anybody trying to collect any debt that's been discharged. So most of the time, what happens with a garnishment is when the creditor gets notice of the bankruptcy, they'll contact the garnishee, or the debtor can contact the garnishee, and none of the debtor's money can go toward that garnishment because all of the debtor's income is under the protection of the court. So it would, and in most cases does, permanently stop a wage garnishment, because when you get out the other side, you go through that chapter 7 4 months later, and the discharge is issued, there's no underlying debt to be paid to the garnishee.
So in summary, it sounds like bankruptcy does eliminate the garnishment for most cases, unless there was an objection.
Yeah,
in the court.
except that would be a real one-off. I think if you wanted to make a general rule, you would say, yeah, the garnishment will go away and it won't come back.
Okay, that's great to know.
Yeah.
Well, I have one other question before we jump into some real user questions or real people questions. At the debt hotline, we collect real questions from real people about debt topics and financial topics. And so we have a list of questions from real people that
Okay.
about bankruptcy. But before we jump into those, I did want to ask one more question. Given that you have decades of experience in bankruptcy law, Stephen, what would you say to someone who is considering bankruptcy? Like, what are some things that they should consider before actually deciding to file?
Well, one of the things, and I get this question on practically every bankruptcy consult that I do, is what's going to happen to my credit if I file for bankruptcy? And a lot of people, when they're coming in the office, they already have credit that's damaged. They've missed payments, and so they're not worried about preserving a good credit score. Sometimes people will come in and they have a good credit score, and they'll say, "Well, I'm holding it together, but it's going to fall apart real soon, and so I want to get out ahead of it." And so, regardless of what your credit situation is right now, bankruptcy is not going to be good for it. But bankruptcy will do a couple of things that will make your credit bounce back faster than just trying to pay everything off. And what happens is once you get a discharge, right, Chapter 7 discharge, you're kind of a great credit risk because A, you don't have any debt, and B, you don't have bankruptcy. The law won't allow you to file a Chapter 7 if you filed a previous case within the prior 8 years. And so, you don't have that protection. So I find that a lot of the Chapter 7 debtors get offers for credit, not credit cards, not great credit cards. I mean, they're low limit, high fees, high interest, but they do allow the creditor or they do allow the debtor, the consumer, to rebuild their credit. And once you have a couple of cards, even if they're not great cards, if you're paying on them every month and you're not in default, that is one of the biggest drivers of your credit score, is your most recent pay history. And so as you log more months of on-time payments, it causes your credit score to go up. Now, if you need a car loan, let's say, car loans are pretty easy to get, even if you have a bankruptcy, except they're just going to want to charge a high interest. You can get a car loan because they want to sell you a car. So, they charge you more interest to reflect the risk that you had credit problems in the past. But, it's possible to get a car loan. A home loan, and I get this question a lot, especially with young people who, want to start fresh and they're looking at a home loan. Home loans are really hard. The Chapter 7 will hang on to your credit report for 10 years. It'll be just the fact that you filed for bankruptcy is reported on your credit file. So if you're applying for a home loan, they're going to say, have you filed for bankruptcy in the last 5 years, 10 years? It varies with different lenders, but if you say I have filed for bankruptcy within the last 5 years, in my experience, that's going to be an automatic decline. If you want to buy a home, it's generally better to have a partner that can go in on it with, and even if you've got the funds now that you're out of bankruptcy to help pay the mortgage, it's going to be hard. There's federal rules about mortgage underwriting and stuff, and if you're under 5 years, you're going to have trouble getting a home loan. So I always want to make sure people understand that. The other thing to keep in mind, a lot of people have military clearances, and one of the things they look at is your credit. And if I always check with people, do you have a security clearance? Because that will mess up your security clearance if you file for bankruptcy. I've seen it happen where they're like, I lost my security clearance because I filed. So that's something, another little thing that does affect a fair number of people. But it's not the thing you would think of. You're thinking, I can't get a credit card. It's like, no, I'm going to lose my security clearance. So that's another thing that I try to make sure people know about.
I didn't even know about that last one, but it sounds
Yeah,
like, in summary, like the biggest things to consider are the way it's going to affect your credit, and if you're planning to like take out any loans in the near future, how it could maybe complicate doing that, right?
right, right. Yeah, if you're, I do a lot of work with folks that are seniors. They've just got all this debt. They want peace of mind. They might be on Social Security, which is not attachable by creditors. And they just want the peace of mind. They're not worried about their credit. They sometimes make some of the best candidates for chapter 7. But again, people who are retired now were brought up in that 20th century concept of pay your bills, and so they're less likely to, unless you sort of talk to them a little bit about that it's okay. It really is okay. you know
Yeah. Well, awesome. That's great. Those are some great thoughts from an expert in bankruptcy. Thank you so much for sharing, Stephen. I think we'll spend the rest of our time, and we'll probably end here in about 10 minutes. But
Okay.
we'll spend the rest of our time looking at these real questions from real people. But before we jump into those, I did want to give a quick disclaimer that yes, Stephen is an attorney. For anyone listening, he is a lawyer, but none of the information we're going to be sharing from this point on is like technically legal advice. So if he's answering one of your questions, please don't take it as, advice applicable to your particular case. But just know that this is general information from
Hmm.
a real bankruptcy attorney. So
Gotcha.
anything else you want to add to that, Stephen, before we jump in?
No, not at all. Let's hear
Okay,
it.
cool. So our first question comes from Rachel in
Sure.
California.
Mhm.
Rachel says, my wages are being garnished for a $9,000 credit card judgment. If I file Chapter 7, will the garnishment stop immediately?
Short answer, yes. And kind of how we described where this person has a judgment against them in a state court, and the remedies on execution are things like levying on property and garnishing your wages. That once you file for bankruptcy, the automatic stay ends all that. And if the $9,000 debt is ultimately discharged, um, then if it's ultimately discharged, then the garnishment can't come back because the underlying debt is gone. So yes, that would stop immediately.
And you mentioned earlier that the automatic stay goes into place like as soon as you file, correct?
The moment you file, I've literally had people run from the bankruptcy court up to where they were doing the sheriff sales, and this is back in the day when there were paper filings, but people would get it stamped by the court, and they'd run up there and they'd say, we're in bankruptcy. That comes up in foreclosures a lot, but it's like everything has to stop.
Yeah.
Any kind of state court enforcement has to stop. So
And that stops immediately. But then, like you said, I think you mentioned earlier, there is that objection period where creditors can file any objections. And
really, really rare though. Really,
that's
really
rare.
rare. Yeah,
Gotcha.
I that would be something if somebody's filing. That would be a one-off. I think to state it, the general answer to Rachel's question is yes, it will start immediately.
Great. Okay, next question comes from Angela in New York. Angela says, I have $45,000 in medical debt and I just got sued. Can bankruptcy make this lawsuit go away completely?
In general, without knowing any of the other information, yes. Medical debt is perfectly dischargeable in bankruptcy, just like credit card debt, signature loans. The $1,000 you owe your Uncle Tim, that can be listed, and all those different kinds of unsecured debts can all be discharged in a Chapter 7. Sometimes you end up in a Chapter 13 to preserve specific assets, like your home. You have a foreclosure and you want to catch up on the arrears through the Chapter 13. You may be able to save your home, but that doesn't mean you have to pay back any of the unsecured debts. It's only if you have, money beyond what your income is, or you have assets to be liquidated. So it's powerful. It's very powerful.
Awesome. Well, next question comes from David in California.
Okay.
So David says, I had my car repossessed, but the lender says I still owe $12,000. If I file for bankruptcy, does that balance get wiped out?
Yes, and we actually touched on this a little bit earlier. So let's say you have a vehicle, take out a car loan, you're underwater for the first few years anyway. You can't make the payments, they repossess it, they sell it, and let's say the debt's 40,000 and they get, like we have here, and so there's a deficiency balance, which means we didn't get enough from selling the car to pay off the balance, so now you owe the rest. That part that you owe the rest is an unsecured debt. And so that would be included in the Chapter 7 list of debts. And then ultimately that would be discharged. And a lot of people, I think I mentioned earlier, a lot of people do Chapter 7 to get out from under a bad car loan that, for whatever reason didn't work out. Unemployment, domestic problems, sickness, all those things, prevent people from living out their best intentions. So that's one powerful use of Chapter 7, is to get out from under deficiency balances on car loans and boats and, all kinds of things like that.
Other kinds of vehicles.
Right,
Cool.
exactly.
All right. Next question comes from Carol in Texas. So Carol
Okay.
says, my paycheck is already being garnished for child support. Now a creditor is trying to garnish it too. Does bankruptcy cover both?
As we talked about before, the child support, that garnishment's not going to go away. Because just from a policy standpoint, parents and kids have to get their child support, and you can't hide behind bankruptcy to stop paying it. Now, if you have this creditor, this credit card creditor come along, if they get a judgment, and it's not, in my practice, if a person gets a judgment, we always make sure that it's limited and qualified to say, well, we're going to pay so much, and you can't do anything. You can't take, you can't levy my car, you can't garnish my wages. We make sure we get that when we do those agreements. So bankruptcy would, if there was a judgment on the credit card, bankruptcy would end the garnishment for that one, but the child support garnishment would continue. And then I don't know, under different state laws, there's different priorities. If the employer has a child support garnishment and just a state law judgment garnishment, I think they have to give priority to the child support garnishment, but that's going to vary from state to state.
You mentioned earlier, so I know that obviously laws vary by state, but you did mention earlier that bankruptcy is outlined in the Constitution, making it like a federal legal system, right? And so for the most part, do you feel like bankruptcy law is pretty uniform across states?
It is. It absolutely is. All the bankruptcy courts use the same bankruptcy code, and the procedures have been made uniform. The e-filing procedures, they've all been made uniform, and because bankruptcy law applies in every federal jurisdiction, you're going to get mostly uniform results. There's different courts that are a little bit more pro-debtor, where if it's a close call, they might be more likely to go, with allowing an objection to a discharge. But in general, for the average person, the justice that's dispensed is pretty uniform across the states, and that's exactly why it's federal law. So that if I've got, say you get a judgment against me, and it's discharged in bankruptcy, and there's, they can't just take it to another state where there's, no exempt, let's say the debt is exempt under Delaware law, which is where I practice, but it's not exempt under Pennsylvania law. The person could just take that judgment, go to Pennsylvania, and try to, levy on a person's assets. And the founding fathers understood this, that the uniformity among all of the states and how they do their debt collection was important enough for them to think of it and say, we're going to do it this way. So it's generally pretty uniform. The procedures are uniform. The forms and schedules the court requires, they're all uniform. Some of them have a couple extra things that they want, but in general, it's going to be uniform across the states.
Thank you. Yeah, that's super, I think, important for people to realize, like, bankruptcy goes back hundreds and hundreds of years in this country, and
it helps take some of that stigma off it, because you think, well, the founding fathers, they were probably wound pretty tight. They weren't giving things away, and they thought of this. So this is not a new problem that people are faced with. This is something that people have been facing for hundreds of years. It's just public perception, judgy people, and like, you don't know what my life is. Don't judge me.
Point.
But people self-judge, and they are afraid to get the relief that the law allows them. So that's, if you can get somebody over that hurdle, but a lot of people just have a problem with it, and it's okay.
Yeah. Well, I love that. I think we have time for maybe one more question, if that's all right with you, Stephen.
Yeah, sure.
So let's see. This question comes from Alan in New York. Alan says, I've been looking into bankruptcy for back taxes over 7 years, starting in 2013. Is this something that, he specifically says, what should I do? But I know you can't give like legal advice, right, Stephen? But how would that work for someone who owes taxes?
Here's the thing about taxes. That's one of those other things that are, from a policy standpoint, are not able to be discharged except under, circumstances that we don't need to get into. The general rule is that things like taxes, the government get a priority claim for taxes. That's so that's something that is hard to discharge, but in practice, the IRS is usually pretty willing to work with people. It's been my experience to try to, get their tax situation squared away. You see a lot of this, tax relief. The government, wants people to start paying. And so they can, once you're in bankruptcy, then you're in a position to really negotiate with the IRS to see what can be reduced. But in general, if you've got back taxes, there are all kinds of rules in the IRS about how far back can you go. What about unfiled returns? Without getting into all the specifics of that, in general, tax debts are not dischargeable, but they're open to settlement. And depending on, I don't know what returns were filed, there's different statutes of limitations, depending on if you filed your return or didn't file your return. You'd have to get into the specifics of, what those taxes consist of. If we've got 7 years of taxes, you got to look at the specifics to know if it can be teed up for discharge as being, say, too late. He goes back to 2013. It's those old taxes might be barred by a statute of limitations, but again, that's real specific to the person's tax situation.
Gotcha. So it sounds like this is a little bit more of a complicated question, but it's nice to know that the IRS is willing to work with people who may.
Yeah, in fact, and student loans is another one you'll hear a lot about. And the bankruptcy courts, the law has been, without getting into too much detail, the bankruptcy in general, you could never discharge any student loans in bankruptcy. And I think that comes from the way it was explained to me. Somebody said, oh, these doctors all go to medical school, they discharge their medical bill debts, and then, now they can go on and make all kinds of, doctor money. And so they close that loophole. But unfortunately, it doesn't just catch, doctors, who are trying to, I don't want to pick on the doctors, but it also affects regular people who aren't going to go off and earn a six-figure income after their bankruptcy. So student loans is one area where it's really hard. Interestingly, if you have a judgment entered against you for damage that you caused while driving drunk, that is not dischargeable. That was a loophole that was closed. Probably a case like that, and they closed that. Also, child support obligations are not dischargeable. So those are going to be a hard stop. With the taxes, it really depends on, how many years is it? What years did you file? How much is the taxes? But so I guess in summary, it's maybe.
Gotcha.
It depends. That's what, as a good lawyer, I always say, it depends.
Love that. Well, I think we're about at time, but I did want to just, put in a little plug for Guardian Litigation Group.
Mm-hmm.
So again, Stephen is a lawyer there, and Guardian Litigation Group can help people who, are looking into bankruptcy options, or who need help with like just consumer rights defense.
Yeah, Guardian Litigation Group is that's my employer, and their primary business is in the debt resolution business. You come to them, and they look at your debts. They calculate how much you probably will need to put in order to pay these debts off, and Guardian settles them. They contact the creditors. They'll take anywhere from 50 to 80% on the dollar. Give you time to pay. And that's what we do at Guardian, is we negotiate those kinds of soft landings for people where it's like, oh no, I owe $10,000. How am I going to resolve this? It's like, well, how about if we make it $8,000 over 24 months? That's something that's a lot more doable for people. And people who don't want to have have bankruptcy on their record will want to do that. And that works out for most everybody, but sometimes it's just, the income's not there to support the debt settlement program. And that's when, we talk about bankruptcy and say, like, your best bet might be to just go into bankruptcy and discharge this. And so, but Guardian is there in all of those capacities to help with debt settlement. But if you need bankruptcy, you can just slide over there too. I
love it. So it's just really kind of like a one-stop shop for like all sorts of legal debt defense or bankruptcy.
Right. And it allows you to not have a conflict of interest about what you're advising your client. Because if you don't do bankruptcy, there might be this thought that like, well, if you did bankruptcy, maybe you'd suggest it to me. And it's like, and so it is like a one-stop shop. That's our goal.
I love that. Well, Stephen, thank you so much for taking the time to be our guest tonight on the Debt Hotline.
Happy to do it. Happy to be here.
It was really great to get to like pick your brain and learn from an expert, as I've mentioned multiple times, someone who's been doing this for literally decades. So thank you so much for your insights, for sharing your expertise. And I just also wanted to say again, if you have questions about debt, you can contact us at the Debt Hotline with Team Solo at 801-613-8181. We respond to real questions about debt twice a week on the Debt Hotline. So, and if you have questions or are being sued for debt and don't know where to start, Solo Suit, we have all sorts of resources on our website, solosuit.com. We've got a blog with lots of resources on, how to represent yourself if hiring an attorney is outside of your ability to pay right now. But again, if you are looking for debt defense or help with bankruptcy, Guardian Litigation Group is also a wonderful resource. So, Stephen, thank you so much again for the time. We really appreciate having you on.
All right, Hannah, thanks a lot. Hey, invite me back.
Yeah, for sure. We we really appreciate you sharing your expertise, like I said before. And thanks everybody for tuning in to the Debt Hotline. Just know that Team Solo is rooting for you. Guardian Litigation Group is also rooting for you. We want to help real people resolve real debts and get a fresh start. So thanks everybody for listening.
All right, thanks.